Hello, I am Renee Lesk, a member of the Board of Directors of the League of Women Voters of Glendale, Burbank. With me today are Tom Carson and Susan Hallgren and Di Rodriguez and Mary Dixon, also from the League. This year, the League of Women Voters is celebrating its 96th birthday. It was formed in 1920 when women first gained the right to vote. Our League has been active in the Glendale and Burbank communities since 1940, so we are celebrating our 76th birthday. Membership in the League is open to all persons of voting age, men and women. Associate membership is open to all others. Our website is www.gb.ca.lwvnet.org. You can also find us on Facebook and Twitter. The League of Women Voters is a recognized leader in voter education. We provide complete and nonpartisan descriptions of candidates and ballot propositions. Today, we will present nonpartisan information on the 17 ballot measures on the upcoming November 8th general election ballot. Our presentation of each proposition will be in 4 parts. We will describe the existing situation, the proposed changes inherent in each proposition, the estimated fiscal effects of these changes, and then present the key arguments in support and opposition. It is important to note that the League of Women Voters does not write these arguments for or against the propositions. We are just telling you what the supporters and opponents of each measure are saying. The League does not vouch for the accuracy of any of the arguments. For your convenience, the League of Women Voters has nonpartisan voter information on the internet. We'll tell you more about that at the end of our presentation. And here is Tom Carson with the first proposition, number 51.
Yes, Proposition 51 addresses school bond issues. Because that is involved, we thought it would be helpful to provide background information regarding the state's current bond debt, as well as the impact that approval of that would have on the framework of the state's overall general obligations and the cost of paying them off. What are bonds? They're a form of long-term borrowing that the state uses to raise money for infrastructure projects. The state sells bonds to investors and agrees to repay the investors with interest according to a specified time schedule for each bond. Bonds are used because projects such as roads, educational facilities, prisons, parks, office buildings, etc., involve large dollar costs and are used over very many years. The use of bonds helps to fund the initial large dollar costs, which would be hard to fund out of day-to-day operating revenues. Also, the repayment of these bonds over time means that future taxpayers who use the benefit from these facilities will help to pay for them. So, Proposition 51 asks whether the state should issue $9 billion in general obligation bonds, the proceeds from which would be used to upgrade public education facilities. Currently, the state funds school projects through the sale of general obligation bonds, all of which must be approved by the voters. From 1998 through 2006, our voters approved $40 billion of such bonds, but virtually all of these funds have now been spent. For the current fiscal year, the state must pay about $3 billion servicing the outstanding bonds, paying principal and interest. Under the state's existing school facilities programs, schools submit project proposals to the state. The proposals may be to buy land, to construct new buildings, to renovate old buildings, etc. In most cases, the schools that receive state funding must also contribute local funding to their projects, normally 40 or 50% of the total cost, depending on the type of projects. Schools that lack sufficient funding may apply for additional grants for up to 100% of the project cost. That's true for K through 12 education, but there's no similar facility for community college districts. School and community college districts often sell local general obligation bonds to help cover their cost of such projects, and these bonds must also be approved by the voters. Since 1998, school and community college districts have sold $64 billion and $21 billion, respectively, to fund local obligation bonds. So what does Proposition 51 propose? It would authorize the state to sell $9 billion in general obligation bonds, $6 billion to modernize old or construct new buildings, $2 billion for community college districts, and $1 billion for charter schools and vocational facilities. This proposition was the first instance where private interests, in this case building contractors and construction trade unions, placed such a bond proposal on the ballot, whereas previously the state legislature had been the one to do that. The fiscal effects of this proposition is that it's likely that the state would actually issue the bonds and sell them over a period of about 5 years, and then pay them off from the general fund revenues over a period of about 35 years. The bonds are sold at an average interest rate of 5%. The total cost to pay off the $9 billion of bonds would be $17.6 billion, including both the principal and interest. The average payment per year would be about $500 million, which would be over and above the $3 billion that's already being paid for past bonds. The supporters of this proposition say that a statewide bond is the best option for meeting California's school construction needs. Local voters will still be in control of how the bond funds are spent. They also say that many school and community colleges throughout the states have outdated facilities and need repairs to meet basic health and safety standards. On the other hand, the opponents of the proposition say that local school bond measures work better than statewide bonds. Local control is the best way to minimize government waste. Prop 51 funding would go to those first in line. The large wealthy districts would receive the lion's share because they have the resources to quickly apply and obtain the funding. As of October 10th, 2016, contributions in support of this proposition totaled $10.6 million, including those from the California Coalition for Adequate School Housing, which contributed $2.2 million, the California Building Industry Association of $1.6 million, and the remainder largely came from very many other building contractors and trade unions. As of October 10th, no contributions had been received by those opposing the proposition. The next proposition, Proposition 52, addresses the Medi-Cal hospital fee program. The proposition asks whether a fee charged on private hospitals to facilitate Medi-Cal funding should be made permanent, whether the legislature's ability to change that fee should be limited, and finally, should the state constitution be amended to exclude this revenue from California's education funding calculations. Currently, the Medi-Cal program provides basic health care benefits to eligible low-income Californians, currently a total of 13 million people. Generally, the state and federal governments share the cost of the program equally, but for some types of costs, the federal government pays slightly more than the state. Since 2009, the state has charged most private hospitals a fee. In the current year, it totaled $4.6 billion, which funds the state share of increased Medi-Cal benefits and state general fund savings. From the resulting increased state and federal funds, hospitals currently receive a net benefit of $3.5 billion. Since the fee was first initiated, the legislature has extended the fee 4 times and could potentially extend it again even without Proposition 52. It currently ends as of January 1st, 2018. Any extension of the fee by the legislature or by this proposition must also be approved by the federal government as part of its sharing of the funding. So, what does the proposition propose? It would make this private hospital fee permanent. The legislature could only end the fee by a 2/3 vote in each house of the legislature, an increase from the current requirement for a majority vote. Changes to the fee generally would require future voter approval in a statewide election. However, there are circumstances where the legislature with a 2/3 vote could make certain types of changes without voter approval, such as in order to obtain federal approval of the program. The state constitution requires an annual minimum funding for K through 12, 14 education based on the state's general fund revenue. This is due principally to Proposition 98, which was approved by the voters some years back. As is true under the existing program, Proposition 52 would continue to exclude that revenue from the calculation of the amounts which must be paid each year to K through 14 education. And what are the fiscal effects of this? The fiscal effect of the measure is unclear primarily because it's not known whether the legislature would have extended the fee in the absence of the proposition. If the fee would have been extended by the legislature, Proposition 52 would have little impact because that fee would continue in any event. But if the fee would not have been extended by the legislature, Proposition 52 would have a major fiscal effect, which essentially would be equal to the current program that's provided under the legislation. Each of these impacts, however, could also be affected by new federal requirements governing this whole fee program, which requirements are not yet known. Supporters of the proposition say that it ensures that the state will continue to receive more than $3 billion a year in federal matching funds for Medi-Cal that would otherwise not be available. Also, it would prohibit the legislature from using this fee revenue for any other purpose. The opponents of the proposition say that it gives $3 billion a year in federal health care benefits to hospitals with no oversight or accountability and no guarantee that it will be spent on health care. They also say that it rigs the system in favor of corporations and hurts low-income people. As of October 10th, contributions in support of this proposition totaled $13 million, including those from the Dignity Health Care System, which has contributed $8.5 million, the California Health Care Foundation, which has contributed $2 million, and the AHMC Healthcare Program, which has contributed $1.2 million. As of October the 10th, the contributions in opposition of this proposition have totaled $12.1 million, including $4.8 million from the Service Employees International Union's United Healthcare Workers West. The next proposition, Proposition 53, addresses voter approval of revenue bonds. The proposition asks whether statewide voter approval should be required before any state revenue bonds can be issued or sold for projects where the total bond amount would exceed $2 billion. Currently, the state funds its operating costs and services and maintains statewide infrastructure by using tax revenues as they are received each year, sort of a pay-as-you-go program. But for larger infrastructure and building projects, the state typically borrows money by selling bonds to investors, which over time are paid back with both principal and interest, as we discussed earlier. There are two main types of bond: general obligation bonds and revenue bonds. The state repays its general obligation bonds, such as school bonds, out of the state's general fund. Revenue bonds, on the other hand, are typically repaid from revenue generated by fees or other charges paid by the users of the projects that are being funded, such as bridge tolls for bridges, rent for office space, utility rates for funded utility facilities. The general obligations always require statewide voter approval before the state can issue them, but historically, state revenue bonds do not require any statewide voter approval at all. So this proposition would propose that statewide voter approval be required for revenue bonds if the total sold by the state for a particular project will be $2 billion or more over the project. It will dividing large projects into separate smaller projects would be prohibited so that they can't get around this requirement. The law would apply to all projects financed, owned, operated, or managed by the state, and all projects financed, owned, operated, or managed by joint agencies formed between the state and local city or county governments, joint coalitions with another state or with the federal government. The fiscal effects of this Proposition 53 are not really known. The financial impact on state and local government, both short-term and over time, would vary on factors such as which projects are affected, the outcome of the statewide vote, and whether alternative projects or activities could be implemented instead that would result in higher or lower costs compared to the original project. Supporters of Proposition 53 say that it ensures that voters choose whether or not the state can implement extremely large, expensive projects, such as the bullet train or the proposed tunnels under the Delta. It also will partially close a loophole in state law that requires voter approvals for general obligation bonds, but not revenue bonds. And finally, it would help protect California's long-term fiscal health by discouraging spending that adds to the state's debt load. It also mandates transparency about the true costs of projects and hold politicians accountable. The opponents of Proposition 53 say that it will take away local controls by requiring a statewide vote for many local programs, rather than leaving control with those most affected. They say it will prevent or delay repair or maintenance of the state's water systems, the most pressing infrastructure issue the state currently faces. They say it will prevent or delay infrastructure and maintenance of infrastructure projects and systems after emergencies or natural disasters, and it can jeopardize California's long-term economic health and safety due to the putting off of necessary infrastructure work. As of October 10th, 2016, financial contributions in support of this Proposition 53 total $4.6 million, all from Dean and Joan Cortopassi. He's a retired businessman and farmer from the Central Valley. The opponents of this proposition, as of October 10th, had received contributions so far of $5.7 million, including the Brown for Governor 2014 Committee, which has contributed $1.7 million. The California Democratic Party has contributed $1.3 million. The California Construction Industry Labor Management Cooperative has contributed $350,000, and the Laborers Pacific Southwest Regional Organizing Coalition has contributed $300,000. And now Renee will discuss the next propositions.
Proposition 54 addresses legislature procedures and proceedings. The proposition asks, should all bills before the legislature be printed in their final form and posted online at least 72 hours before being voted on? And should all public meetings of the legislature be videotaped and posted online within 24 hours? Currently, legislative rules govern the process by which bills become laws. Legislators discuss bills in committee hearings and other meetings and make changes to bills based on these discussions, a process that usually takes place over days, weeks, or months. However, bills can also be drastically changed at the last minute, including adding hundreds of pages of new text. In a procedure known as gut and amend, every word of a bill may be replaced at the last minute with new language, which can be even on a totally different subject. When this happens, the public cannot read the bill in its entirety before it is passed into law, and many legislators cannot read the bill in its final form before voting on it. Additionally, recordings of the legislature's public proceedings are not always made, so meetings and discussions about a bill can take place unobserved by the public or the press without any record of what was said or who said it. Proposition 54 proposes that legislative rules be amended to require that every bill in its final form be made available to legislators and published on the internet at least 72 hours before the vote, except in cases of emergency. Require the legislature to make audio-visual recordings of all its public meetings and ensure that these recordings are available on the internet for viewing within 24 hours. Allow anyone to record public legislative meetings. Allow recordings of public legislative meetings to be used for any legitimate purpose. Fiscal effects are likely one-time costs of $1 million to $2 million to buy cameras and other equipment, and annual costs of about $1 million for more staff and online storage for the videos. These costs would be less than 1% of the legislature's budget for its own operations. Supporters say that Proposition 54 will give the public and their elected officials time to read and express their opinions on legislation before it is enacted into law. put an end to the practice of gut and amend, ensure that all open meetings of the legislature are recorded and posted online so the public can view them. Opponents say that Proposition 54 will introduce unnecessary, burdensome, and time-consuming restrictions on the way laws are written, make small technical but needed changes in bills introduced at the end of legislative sessions more difficult to accommodate, give lobbyists and special interests extra time to lobby and launch campaigns to attack hard-fought bipartisan compromises. Supporters, a yes on 54 as of October 10th, financial contributions in support of Prop 54 total $10.6 million, almost all from Charles T. Munger, Jr. As of October 10th, opponents have given no financial contributions in opposition to Prop 53. Proposition 55 proposes a tax extension to fund education and health care. The proposition asks, should the state constitution be amended to extend certain existing income tax increases on high-income taxpayers through 2030 and increase funding for Medi-Cal benefits? Currently, this year's state general fund budget is about $122 billion, with over half going to education and about 1/4 going to health and human services, including the low-income Medi-Cal program. Income taxes imposed on payroll, investment income, profits from the sales of stock or other assets, etc., provide about 2/3 of general fund revenues. Income tax rates increase as a person's taxable income increases. In 2011, individual income tax rates ranged from 1% to 9.3%. In 2012, voters approved Prop 30, which increased income tax rates by 1% to 3% through 2018 on high-income taxpayers, defined as individuals earning more than $263,000 a year and couples earning more than $563,000 a year. In the current year, these Prop 30 marginal income tax increases will raise about $7 billion, all for K-12 schools and community colleges. The state must spend a minimum amount annually on K-12 schools and community colleges. This year, the general fund will provide over $50 million towards this minimum guarantee. Local property taxes also contribute to this obligation. The state's Medi-Cal program provides health care services to over 13 million low-income people, roughly 1/3 of the state's population. It relies heavily on federal funding and receives some support from other state sources. Prop 55 would extend the Prop 30 income tax increases on high-income taxpayers an additional 12 years from 2018 to 2030. Income tax increases would vary greatly by level of income. On a single person's income of $300,000, there would be an additional tax of $370, while on a married couple's income of $2 million, there would be an additional tax of about $38,000. These additional revenues would continue to provide funds to K-14 education, but would also be directed to the Medi-Cal program based on a new formula for its funding. Prop 55 would not extend Prop 30's sales tax increase, which will expire at the end of 2016. Fiscal effects of Prop 55 are increased revenues that would be used for education, healthcare services for low-income people, and other state budget purposes. The amount of additional state revenue is uncertain. Depending upon the general economic conditions in each year, the increases could range from $4 billion to $9 billion. Roughly half of any revenue increases would go to education. Additional Medi-Cal funding under Prop 55 could vary significantly, possibly ranging up to a maximum of $2 billion per year. Prop 55 could also increase annual contributions to rainy day budget reserves and annual payments of state debts by $60 million to $1.5 billion or more. Supporters say that Prop 55 maintains existing tax rates so the wealthy pay their fair share to provide adequate funding for education and health care. Also, Prop 55 has strict accountability requirements, making sure that the funding reaches the schools. Opponents say that voters who approved Prop 30 were promised that the increases would be temporary, not permanent. Also, Prop 55 tax increases are not needed to adequately fund education, healthcare, and state government, and would be a job killer. As of October 10, supporters and contributions in support of this proposition totaled $52.7 million, including those from the California Association of Hospitals and Health Systems for $25 million, California Teacher Association for $21.1 million, and SEIU California for $2.8 million. Opponents are the Howard Jarvis Taxpayers Association. As of October 10, contributions in opposition to this proposition totaled $3,000, made up of $1,000 each, from Franklin Antonio, Martin Schwartz, and Paul Wick. Proposition 56 addresses an additional cigarette tax to fund healthcare, tobacco use prevention, research, and law enforcement. Prop 56 asks, should California increase taxes on tobacco and electronic cigarette products containing nicotine to fund healthcare and tobacco control programs? Currently, tobacco products are subject to state and federal excise taxes. California imposes excise taxes on distributors plus sales and local taxes paid by consumers on the final price at the time of purchase. California's average retail price for a pack of cigarettes is about $6, which reflects $1.01 federal excise tax, 87-cent state excise tax, and an average of 50 to 60 cents sales tax. California's current excise tax on other tobacco products is equivalent to $1.37 per pack of cigarettes. Electronic cigarettes are not currently subject to state or federal excise taxes, but are subject to state and local sales and use taxes. Prop 56 proposes it would increase the amount of state excise tax on cigarettes by $2 per pack to a total of $2.87, with a per pack equivalent of $3.37 excise tax for other tobacco products, including electronic cigarettes. Revenues from the excise tax increase would go into a new fund to support existing tobacco control and healthcare programs, with some monies going to enforcement of tobacco-related laws. Prop 56 would amend the state constitution to exempt spending from the state spending limit and exempt revenues from minimum funding requirements for education, similar to earlier voter-approved tobacco taxes. Fiscal effects. The Legislative Analyst's Office estimates that as a result of Prop 56, consumers may reduce the quantity of tobacco products they purchase and possibly change how they buy those products, such as through internet purchases rather than local retail outlets. Nevertheless, the LAO estimates that Prop 56 would generate an estimated $1.3 billion to $1.6 billion in new excise tax annual revenue on cigarettes and other tobacco products, including e-cigarettes, depending on consumers' response to the new tax. A decline in consumption of cigarettes and other tobacco products caused by Prop 56 would reduce revenues that support the health and wellness programs currently receiving tobacco tax funding. Money from Prop 56 would be required to backfill those losses in an estimated annual amount of $200 million to $230 million. Supporters say that cigarette smoking kills more than 40,000 Californians annually. Tobacco tax increases are one of the most effective ways to reduce smoking and other tobacco use. Taxpayers pay $3.58 billion every year for tobacco-related healthcare costs. Under Prop 56, tobacco users will pay to help offset this cost. Prop 56 doesn't take a dime from schools. It protects school funding while helping to keep our kids from getting hooked on deadly, addictive tobacco. Opponents say that Prop 56 is not what it appears to be. Insurance companies will be paid $1 billion more for treating the same Medi-Cal patients they treat today. Prop 56 allocates just 13% of new tobacco tax money to treat smokers or stop kids from starting. Prop 56 was written to undermine our Constitution's school funding guarantee, diverting at least $600 million a year to health insurance companies and other wealthy special interests. As of October 10, 2016, financial contributions in support of Prop 56 total $23.2 million, including California Association of Hospitals and Health Systems for $10 million, Thomas F. Steyer for $5.5 million, and SEIU California for $2.1 million. As of October 10, financial contributions in opposition to Proposition 56 total $66.3 million,
including Philip Morris USA for $35.5 million, R.J. Reynolds for $23.9 billion, and Altria Group for $4 million. And now Susan Hallgren will present Prop 55.
I'm doing Proposition 57, addresses criminal sentences, parole, and juvenile criminal proceedings and sentencing. The proposition asks, should prisoner inmates convicted of certain nonviolent crimes be considered for early parole? And should judges, rather than prosecutors, decide whether some juveniles should be prosecuted as adults? The current situation. Prison sentences in California are either determinate, a fixed amount of time, or indeterminate, a minimum but no specific maximum, such as 25 years to life. The majority of prisoners are serving determinate sentences, and some of those are eligible for parole once they have served half of their sentence. Those serving indeterminate sentences are eligible for a parole hearing once they have served the minimum sentence. Limited credits may be awarded for good behavior, such as training or education in determining parole. In 2011, a federal court ordered California not to exceed a prison population of 137.5% of capacity. Currently, 134.8% as of June 2016, or face mandatory release of prisoners. Youths under 18 years of age accused of committing crimes are generally tried in juvenile court, where judges determine placement and treatment. In certain circumstances, youths between the ages of 14 to 18 accused of crimes such as murder or specific sex offenses may be tried in adult court at the discretion of the prosecutor. The proposal, Proposition 57, would amend the Constitution to allow parole consideration for persons convicted of non-violent felonies who have served their minimum sentences and passed screening for public security. Proposition 57 would change state law to require that youths have a hearing in juvenile court to determine whether they should be transferred to adult court, eliminating the ability of prosecutors to make that determination. Fiscal effects. A decline in the prison population due to this measure could reduce the state's $10 billion correction budgets and the tens of millions of dollars offset by costs to conduct more parole hearings. Net county cost would increase due to an increase in the probation population, which is supervised by county probation officers. The transfer of hearing requirements for use would reduce state court cost, offsets by increased cost in the state juvenile facilities, resulting in a net savings of a few $1 million annually. Net county costs would likely increase a few $1 million annually, as counties are responsible for paying for a portion of housing costs in state juvenile facilities as well as probation supervision. Supporters say Proposition 57 focuses resources on keeping dangerous criminals behind bars while rehabilitating juvenile and adult inmates and saving tens of millions of dollars. Without a common sense long-term solution, we will continue to waste billions of dollars and risk a court-ordered release of dangerous prisoners. Opponents say weakening of California anti-crime laws has gone too far. California's Constitution should not be amended to give more rights to criminals. Proposition 57 is a poorly drafted measure classifying crimes such as rape by intoxication and assault with a deadly weapon as non-violent and eligible for early parole. Supporters are Californians for Public Safety and Rehabilitation. Financial contributions total $8.7 million as of October 10th, 2016, including Governor Brown's ballot measure committee, $4.1 million, California Democratic Party, $1.7 million, and Reed Hastings, $981,000. Opponents, which are Stop Early Release of Violent Criminals. Financial contributions totaled $200,081, $632 as of October 10th, 2016, including Association for Los Angeles Deputy Sheriffs, PIC, $100,000, Association of Deputy District Attorneys, $60,000, and David Horowitz, $10,000. Okay, the next proposition is 58, which addresses English proficiency and multilingual education. The proposition asks, should state law be changed to eliminate the requirements that public schools teach English learners only in English, to permit a variety of language acquisition programs, and to allow pupils to enroll in bilingual programs without a waiver? Currently, federal case law, civil rights laws, and state law require public schools to teach all pupils English language skills and academic subjects. In 2015-16, about 2.7 million K through 12 public school students did not speak English at home. A little more than half of them, 22% of all California students, were classified English learners. In other words, having limited English proficiency. Proposition 227, passed in 1998, imposed certain restrictions on the way state public schools teach English learners. 1, classroom instruction must be in English only. 2, special materials may be used to improve the language skills and make instructions more understandable. 3, pupils receive special intensive English instruction for only about a year before moving into English classes only. 4, enrollment in a bilingual program requires a waiver signed by a parent. The state requires school districts and county offices of education to publish yearly plans describing the services they will provide for certain groups of students, including English learners. Proposition 58 proposes that key provisions of Proposition 227 would be repealed, and a few new provisions requiring English language instruction should be introduced. Proposition 58 would remove the requirement that English learners must be taught only in English. It would allow a variety of programs, including bilingual instruction, none of which would require a parental waiver. Community participation would be increased. The annual planning process would include soliciting input from parents and community members as to how English learners should be taught. If parental requests for certain programs reach specified levels, the school would have to provide those programs to the extent possible. Removing the restrictions of Proposition 227 would mean that native English speakers would also be able to learn a language other than their home language. This measure would be amended by a statute approved by a vote of the electorate or by a majority vote of each house of the legislature and signed by the governor. Fiscal effects. State costs would not be notably changed by this measure. Local school district cost would depend on program decisions. In districts where many pupils are placed in bilingual programs, one-time cost would be significant and ongoing costs might also be higher. training materials, class size, communicating with parents, and other factors. Supporters say Proposition 58 allows districts to meet local needs with greater flexibility. Proposed programs must be evaluated objectively based on outcomes and research. Opponents say being surrounded by English speakers leads to faster English language acquisition. Schools shouldn't return to methods that haven't worked. Supporters, yes on 58, Californians for English Proficiency, sponsored by the California State Council of Service Employees. As of October 10th, 2016, financial contributions in support of Proposition 58 totaled $1.9 million, including California Teachers Association, $1.1 million, SEIU Local 2015, $105,000, Association of California School Administrators, $100,000. Opponents, Keep English for Children. As of October 10th, no financial contributions had been received in opposition to this proposition. Proposition 59 addresses state reaction to possible constitutional amendments to overturn the Citizens United Supreme Court decision. The proposition asks, shall California's elected officials use their authority to propose and ratify an amendment to the federal Constitution overturning the U.S. Supreme Court decision in Citizens United versus Federal Election Commission? Currently, there are two main forms of political campaign spending: money given directly to candidates, committees that support candidates, and political parties. And secondly, independent expenditures, money spent in support of or in opposition to a candidate without coordination with the candidate's campaign. Before 2010, federal law limited the independent expenditures that corporations and labor unions could make in federal elections. However, in 2010, the U.S. Supreme Court ruled in Citizens United vs. FEC that independent expenditures by corporations and labor unions are allowed as free speech under the First Amendment. Accordingly, there can be no limitation or regulation on how much money can be given by these entities as independent expenditures. This ruling applies at the federal, state, and local levels. In order to amend the Constitution, Congress can either on its own or upon petition from a sufficient number of states may A, propose amendments to the Constitution, or B, call a constitutional convention for the purpose of that body proposing amendments. Under either alternative, in order for a proposed amendment to take effect, it must be ratified by the legislatures or conventions of at least 3/4 of the states. The proposition proposes that voters be asked to decide whether California's elected officials should use their authority to propose and later ratify an amendment or amendment to the U.S. Constitution that would reverse the effects of Citizens United and related court decisions, thereby allowing government to impose more limits on political campaign contributions and spending, and making it clear the rights under the Constitution are for natural persons only. This is an advisory measure only. It has no legal effect and does not require any particular action by Congress or the California legislature. Fiscal effects. Proposition 59 would have no direct fiscal effect on state or local governments. Supporters say Corporations and billionaires should not be allowed to continue to buy elections. Yet the Supreme Court gave corporations the right to spend unlimited amounts of money in our election. Overturning Citizens United will open the way to meaningful campaign finance reform that will return ownership of our elections back to ordinary Americans. Opponents say Proposition 59 is a waste of your taxpayers' dollars because it will not change the law. Our ballots should not be clogged with pointless, non-binding measures. Instead of working to amend the Constitution, we should work to require the disclosure of political contributions within 24 hours of receipt year-round. Supporters are vote yes on 59, overturn Citizens United. As of October 10th, 2016, financial contributions in support of this proposition totaled $198,000, including Next Gen CA Committee, $61,390, California Democratic Party, $25,852, and Vocal USA Philanthropy, $15,000. Opponents represented by the firm of Gilliard, Blanning and Associates, as of October 10th, 2016, there had been no financial contributions in opposition to this proposition. Okay, and next we'll have Di Rodriguez continue with Proposition 60.
Proposition 60 addresses adult films, condoms, and health requirements. The proposition asks, should performers in adult films be required to use condoms during filming? Should new requirements for producers of adult films be added to the California Labor Code? And should private citizens be allowed to file suit based on violation of these requirements? Currently, the state is a leading adult film industry location, with many such films being made in the San Fernando Valley area of Los Angeles. Adult films are commonly known as pornography. The State Division of Occupational Safety and Health, Cal-OSHA, already requires adult film condom use, as does the Los Angeles County. Cal-OSHA considers exposure to certain body fluids a workplace hazard because harmful sexually transmitted infections, STI, and HIV can spread from infected people to healthy people. In enforcing these rules, Cal-OSHA requires performers to use condoms during sex on adult film sets. Some producers and performers prefer to make adult films without condoms or other protective equipment, and instead use regular STI testing to confirm that performers are free of harmful infections. What does the proposition propose? Proposition 60 would place into the California Labor Code additional requirements regarding workplace health and safety on adult film sets. Adult film producers would be required to provide condoms, ensure that performers use them, and be able to prove that they did so. Producers would have to be licensed by Cal-OSHA, pay licensing fees, pay for the cost of STI prevention vaccine, testing and medical exams, and keep records showing that they complied with these requirements. The time period for enforcement of violations would be expanded, and there would be financial penalties for such violations. Adult film distributors and talent agents could also face liability for violations. Also, any California resident could request Cal-OSHA to address an alleged violation, and if Cal-OSHA did not take action, that person could file a civil lawsuit against the adult film producer. If the individual prevailed in the lawsuit, that person would recover their legal costs and receive 25% of any penalties paid by the defendant. The fiscal effects. Some parts of the industry likely would comply with Prop 60, while others might relocate outside of California or try to evade the law while continuing to make adult films. Adult film wages and business income would likely decline, resulting in reduced state and local revenues by several million dollars per year. Most of the ongoing state costs to implement the law would be offset by the new fees on adult film producers. The supporters say that Prop 60 would close loopholes in existing law and improves enforcement so that the adult film industry is held to the same workplace protection law that applies to every other California industry. Prop 60 is supported by numerous medical and public health organizations. The opponent says that Prop 60, opposed by numerous civil rights and public health organizations and business leaders. Prop 60 creates a dangerous new private right of action authorizing any resident of California to file a lawsuit directly against workers in the adult film industry. As of October 10, 2016, financial contributions in support of the proposition totaled $4.6 million, all of which was contributed by the AIDS Healthcare Foundation. As of October 10, 2016, financial contributions in oppositions to the proposition totaled $388,469, all from adult film companies. Proposition 61 addresses state prescription drug purchases and their pricing standards. The proposition asks, should state agencies generally be prohibited from paying more for any prescription drug than the U.S. Department of Veterans Affairs, VA, pays for the same drug? Currently, the state purchases prescription drugs under various programs covering its current and retired state employees, prison inmates, and medical enrollees. The state may either purchase some drugs directly from manufacturers or reimburse other entities implementing state programs. Significant drug purchasers typically negotiate and receive discounts from manufacturers' list prices. The VA provides health care to approximately 9 million veterans nationwide, including prescription drugs. It is subject to federally imposed upper limits on the prices it pays for drugs, but often negotiates additional discounts, generally achieving lower prices. The VA maintains a public database that lists the price it pays for most drugs. However, the database may not display the lowest price paid for some of the drugs because confidentiality clause in some VA purchase agreements prohibit public disclosures of such information. Federal rules governing Medicaid require common prescription drug pricing across the country so that if Medi-Cal were to obtain lower pricing on certain drugs, all Medicaid programs would have to conform. Prop 61 would generally prohibit state agencies from paying more for a prescription drug than the lowest price paid by the VA for the same drug after all discounts are factored in. This would apply whether the state purchases directly or indirectly through reimbursements of other entities. The state medical program offers comprehensive health coverage to the state's low-income residents, currently about 13 million people. Prop 61 would apply to medical's fee-for-service programs, which serves approximately 25% of medical enrollees, but not to its managed care system, which serves the remaining 75%. Prop 61 would require the state's Department of Health Care Services, DHCS, to verify that state agencies are paying the same or less than the lowest price paid by the VA on a drug-by-drug basis. The fiscal effects. There is the potential for the state to realize drug cost reductions, but there are major uncertainties about the amount of such savings because of the uncertainty of obtaining VA pricing information, the potential impact of federal Medicaid rules, and the reaction of the drug manufacturers. The VA's public database does not always identify the lowest prices the VA pays of its certain drugs, and it might not be possible for the state to obtain this information. Under those circumstances, DHCS would be unable to assess the lowest price paid by the VA for one or more drugs and would be unable to make the certifications required by this proposition. It is possible that courts could allow state agencies to implement laws to the degree that is practicable, such as allowing the state to pay for drugs at a price not exceeding the lowest known VA price. However, that judicial finding is not certain. There are at least two possible manufacturer responses to Prop 61. Drug manufacturers might try to raise the VA's drug prices, or drug manufacturers could refuse to offer California some drugs purchased by the VA. Therefore, it appears that the amount of any savings under Prop 61 could range from relatively little effect to significant annual savings. Supporters say that the skyrocketing prescription prices are a matter of life and death, and Proposition 61 will end price gouging. Proposition 61 empowers the state to negotiate the same or better deals for taxpayers as are paid by the VA. The opponents say that Proposition 61 only covers an arbitrary group of patients in certain government programs. More than 88% of Californians are excluded. Proposition 61 would result in the elimination of drug discounts the state currently receives, increasing state prescription costs instead of reducing them. As of October 10, 2016, contributions in support of this proposition totaled $14.5 million, virtually all from the AIDS Healthcare Foundation. As of October 10, 2016, contributions in opposition to this proposition totaled $86.9 million, provided largely by contributions from major pharmaceutical companies in the range of 3.5 to 7.2 millions each. Propositions 62 and 66 address aspects of the death penalty. If both propositions pass on the November 8 election, the one with the most yes votes would supersede the other. The situation currently is that people convicted of first-degree murder that includes special circumstances such as multiple victims, hate crimes, or killing for financial gain can be sentenced either to life imprisonment without the possibility of parole or to death. 2 trials are required in order to sentence someone to death: 1 to establish guilt and 1 to decide the penalty. Death penalty convictions are then automatically appealed to the California Supreme Court, and they almost always also go through a series of appeals in higher courts. People who cannot afford counsel are provided counsel for both trials and for appeals at taxpayers' expense, a process that can take 15 to 25 years, the combinations costing the state about $55 million annually. Many such prisoners die during the course of these judicial proceedings rather than ultimately being executed. Like other prisoners, inmates on death row are generally required to work, though sometimes they are exempted. A percentage of their earnings may be taken to pay any reparations that they owe to their victims' families. There are currently about 750 people on death row in California. Because the state's lethal injection protocols are currently under legal review, no executions have taken place since 2006. The first of the two propositions, Proposition 62, would propose that the death penalty in California be ended, and this termination would retroactively be applied to inmates currently on death row whose sentences would automatically be changed to life imprisonment without the possibility of parole. Any currently pending appeals not related to the death penalty in these cases would be sent to the lower courts responsible for hearing non-death penalty appeals. All inmates sentenced to life without parole would be required to work, and the maximum amount of their earnings that could be used for reparations would be raised from 50 to 60%. Proposition 62's fiscal effects. The legislative analyst estimates that Prop 62 would save the state approximately $150 million annually. These savings would result from shorter trials, fewer appeals, and reduced prison costs based on the elimination of separate death row facilities. Supporters of Proposition 62 say that since 1978, California has sentenced 930 people to death, but performed only 13 executions at an average cost of $384 million per execution. Abolishing the death penalty will save the state $150 million every year. Victims' families will achieve closure with the end of the long process of death penalty trials and appeals. Abolishing the death penalty removes the risk that innocent people may be executed. Opponents of Prop 62 say the death penalty system is broken, but ending it rewards murderers. The system should be mended, not ended. Changing the time-consuming and expensive appeals process is the best way to fix the death penalty and save taxpayers money. The people on death row are the worst of criminals and deserve the death penalty. Prop 62 jeopardizes public safety and denies justice and closure to victim families. As of October 10, 2016, financial contributions in support of Proposition 62 total $6.5 million, including Nicholas McEwen at $1.5 million, Reed Hastings at $1 million, and Paul Graham at $500,000. Financial contributions in opposition to this proposition also support the passage of Proposition 66, which will be discussed later, and total $4.2 million as of October 10, 2016, largely from contributions by numerous police and sheriff associations. Regarding the second of these measures, Proposition 66, this measure would not eliminate the death penalty, but proposes a number of changes in the way appeals of death penalty convictions are handled through the judicial process. The goal would be a significant shortening of the time that the total judicial process take. For example, instead of going directly to the California Supreme Court, the appeal petitions would be heard by lower courts in which the initial trials were handled. Both direct appeals and other petitions would have to be completed within 5 years from the time of sentencing. Appeals would have to be filed within a year of counsel being appointed and would have to be decided by the courts within a year of filing. Additional appeals would be limited. Appeals counsel would be appointed immediately, and qualified appeal attorneys who handle non-capital offenses would be required to accept appointment for capital cases if they want to remain on the list of qualified appeal attorneys. All inmates sentenced to life without parole will be required to work. The maximum amount of their earnings that could be used for reparations to their victims would be raised from 50 to 70%. Death row inmates could be housed in any California prison rather than just in a few prisons, and execution methods would be exempted from public oversight. Proposition 66 fiscal effects. The fiscal effects of Proposition 66 are very difficult to project because there are varying possible consequences of its many provisions. It could increase the cost of appeals because it requires petitions to be heard by lower courts first. It would also have higher near-term costs, perhaps in the tens of millions of dollars annually, to pay for processing currently pending appeals in their required time frame. This might be offset by saving once inmates are executed and by transferring inmates to other prisons. The supporters of Proposition 66 say the death penalty system in California is broken, but it should be mended, not ended. Speeding up the death penalty appeals process would save taxpayers $30 million annually. The opponents of Proposition 66 say that Proposition 66 is confusing and poorly written and would be subject to costly legal challenges. Additional layers of appeal and construction of new prison facilities would cost taxpayers millions. Financial contributions in support of this proposition also oppose the passage of Proposition 62 and total $4.8 million as of October 10, 2016, largely from contributions from numerous police and sheriff associations. The opponents of this proposition, their financial contribution total $7.6 million as of October 10, 2016, including Nicholas McKeon, $1.5 million, Reed Hastings, $1 million, Open Society Foundations, $903,000. Now, Mary Dixon will discuss the rest of the propositions.
Thank you, Di. Proposition 63 addresses firearms and ammunition sales. The proposition asks, should the state of California ban large-capacity ammunition magazines, strengthen background checks, and Justice Department oversight tighten restrictions and monitoring for gun and ammunition sales, and require the reporting of lost and stolen firearms. The current situation provides that under federal and state law, certain individuals are not allowed to have a firearm. A national background check system exists to ensure that a buyer is not a prohibited person. And the California Department of Justice, or the DOJ, cross-checks it in order to identify illegally possessed guns and confiscate them. Under state law currently, there are also limits on the type of firearms which can be bought, a waiting period before a buyer can get a firearm from a dealer, and requirements for reporting firearm sales. Starting in 2018, a one-year DOJ license will be needed to sell ammunition, and most ammunition sales would have to be made through a licensed dealer. Beginning in 2019, dealers will have to confirm with the California Department of Justice that those seeking to buy ammunition are not prohibited persons, and dealers will generally have to collect and report to the DOJ detailed information on each ammunition sale to be kept for 2 years. Additionally, the ownership of large capacity magazines will be limited. Proposition 63 proposes to change the laws in the following ways. Various regulations relating to the sale of ammunition, some of which would replace existing law, and individuals would have to obtain and pay for a 4-year permit from the DOJ to buy ammunition. Dealers would have to check that buyers have such permits, and the permits would be revoked from those who are prohibited persons. Persons convicted of stealing a firearm would be prohibited from possessing firearms, and a new court process would be set up to ensure that those prohibited from owning firearms don't continue to have them, and new reporting requirements would be established. The maximum penalty for possession of large capacity magazines would be increased. The fiscal effects. There would likely be increased state and local costs in the tens of millions of dollars annually due to increased workloads by the new court process and potential state costs related to the regulation of ammunition sales, which would not likely be more than millions of dollars annually and could be offset by various regulatory fees. Potential increased state and local correction costs likely would not exceed the low millions of dollars annually. The supporters of Proposition 63 are saying that it will save lives by preventing dangerous criminals, domestic abusers, and the dangerously mentally ill from obtaining and using deadly weapons. Supporters of Proposition 63 also say that it will protect the right of law-abiding Californians to own guns for self-defense, hunting, and recreation. The opponents of Proposition 63 say that it is opposed by the law enforcement community and civil rights groups because it will burden law-abiding citizens without keeping violent criminals from accessing firearms and ammunition. Opponents of Prop 63 also say that it will burden the court system with the enforcement of flawed laws. As of today, contributions in support of Proposition 63 totaled $5 million, including $1.1 million from the California Democratic Party, $728,000 from Gavin Newsom's for the Lieutenant Governor 2014 fund, and Sean Parker, who contributed $400,000. The opponents of Prop 63 have contributed a total of $705,000, including contributions from the California Rifle and Pistol Association, the National Rifle Associations, and the Citizens Committee for the Right to Keep and Bear Arms. Now moving to Proposition 64, which addresses making legal the recreational use of marijuana. The proposition asks, should marijuana be legalized in California for use by adults who are 21 years or older? Currently, it is illegal in California to cultivate or use marijuana. Under current law, a person who possesses less than 1 ounce of marijuana, equivalent to 40 cigarettes, could be fined. Selling or growing marijuana could mean jail or prison if convicted. However, marijuana may be used by individuals of any age for medical purposes if their doctor recommends its use. The state is currently beginning to regulate and set standards for medical marijuana use. Federal law prohibits possession or use of marijuana even for medical purposes, but the federal government has chosen not to prosecute individuals or businesses as long as they are following state or local marijuana laws that are consistent with federal priorities, such as preventing minors from using marijuana. Proposition 64 would propose the legalization of marijuana for adults ages 21 or older. The state would levy an excise tax of 15% on retail sales of marijuana and a cultivation tax of 9.25 per ounce of flowers and $2.75 per ounce of leaves. Medical marijuana would be exempt from some but not all of this new taxation. Prop 64 would establish specific ways in which the use of these taxes would be allocated. Prop 64 also names state agencies to license and regulate the marijuana industry and also allows some local regulation and taxation of marijuana. Proposition 64 would impose advertising and labeling standards and restrictions for marijuana products and would prohibit marketing and advertising directly to minors. It would also permit resentencing of individuals previously convicted for activities now made legal and destruction of records for prior marijuana convictions. The fiscal effects of this proposition would be that Prop 64 would bring in net state and local taxes and excise tax revenues that range from the high hundreds of millions of dollars to over $1 billion annually. The amounts would depend on how state and local governments regulate and tax marijuana, whether the federal government would enforce federal laws regulating marijuana, and how marijuana prices and consumption might change. Some of the funds would be annually allocated to programs evaluating the consequences of marijuana use and addressing human or environmental needs resulting from its use. Prop 64 could reduce government costs by tens of millions of dollars annually because of the decline of marijuana offenders now in state prisons and county jails. Supporters of Prop 64 say that it would bring in revenue of over $1 billion and could save tens of millions of dollars annually in reduced law enforcement costs. Prop 64 would end the criminalization of marijuana by creating a safe, legal, and comprehensive system for adult use of marijuana while protecting our children. Supporters of Prop 64 are also saying that it adopts the best practices from states that already have legal adult marijuana use, such as Colorado. Opponents of Prop 64 say that it would increase highway fatalities because it has no DUI standard for marijuana. Opponents are also saying that Prop 64 would prohibit local governments from banning indoor residential growing of marijuana, even next to an elementary school, if the crop is limited to 6 plants. Finally, the opponents of Prop 64 would argue that individuals who are currently selling illegal drugs may become licensed to sell marijuana. As of today, contributions in support of Prop 64 totaled $21.4 million, including $8.8 million contributed by Sean Parker, $5.3 million for the Fund for Policy Reform, and $1.5 million from Henry Van Amerongen. As for the opponents of Prop 64, they have contributed $2.5 million, including Julie Schnauer for $1.4 million, SAM Action, $890,000, and the California Teamsters Public Affairs Council has contributed $25,000. And finally, tonight I will be talking about Propositions 65 and 67 together. This addresses the single-use carry-out bags. Current situation is that in 2014, the state legislature passed and the governor signed Senate Bill, or SB 270. This is a law that prohibited certain retail stores statewide from providing single-use carry-out bags to customers. The law, sometimes known as the plastic bag ban, also prohibited the stores from selling or distributing a recycled paper bag at the point of sale unless the stores charged at least 10 cents per bag. The law provided that the stores retain the money from such bag sales and use the money only for specified purposes, such as covering the cost of providing the bags. SB 270 would have gone into effect on July 2015. However, its implementation was suspended in February 2015 when Prop 67 qualified for the state ballot. In addition to the suspended state ban, approximately 150 California cities and counties, covering approximately 40% of our population, have banned the use of single-use carry-out bag laws, such as Glendale. Prop 67 asks, should the law passed by the legislature, this SB 270, banning single-use carry-out plastic bags be allowed to go into effect? The legal effect of Prop 67 is that it is a referendum, and this means that it asks voters to approve or reject SB 270. A yes vote means that this law will now go into effect. A no vote by you means that the law will not go into effect. Prop 67, whether it is approved or not, has no effect on the similar laws previously passed by California cities and counties. The fiscal effects of Prop 67. Prop 67 would have a relatively small fiscal effect on state and local governments, including a minor increase in state administrative costs and possible minor local government savings from reduced litter and waste management costs. Supporters of Prop 67 say a yes on Prop 67 is a common sense solution to reduce plastic litter in our oceans, lakes, and streams, and to protect wildlife. Opposition to this law is funded by out-of-state plastic bag companies, and supporters of Prop 67 say that these companies are just trying to defeat this law in order to protect their profits. Opponents say that a ban on single-use bags would decrease manufacturing jobs and harm the economy. And opponents of Prop 67 say that California consumers would be forced to spend 10 cents for every bag they are given at checkout, while grocers get to keep the resulting millions of dollars in consumer payments. As of today, financial contributions in support of Prop 67 totaled $1.6 million, including Safeway Grocery of $150,000, California Grocers Association with $112,000, and Ralph's Groceries $80,000. As of today's date, financial contributions in opposition to Proposition 67 have totaled $2.9 million, including contributions from several plastic bag manufacturers. Now I want to tell you about how Prop 65 affects the statewide ban on single-use carry-out grocery bags. If this statewide ban is enacted, that would be by the passage of Prop 67, Proposition 65 would have stores required to offer reusable bags for sale should the money from the sale of those bags go to a special fund for environmental purposes. What Prop 65 proposes is that whenever any state law bans free distribution of single-use bags and mandates the sale of any other kind of carry-out bag, the funds resulting from sales of alternative bags should not be retained by the retail outlets. Rather, Prop 65 would create a new state fund administered by the Wildlife Conservation Board and requires stores to deposit bag sale proceeds into that fund to support certain environmental projects. Prop 65 would only be implemented if the legislature's bag ban is held up by the voter approval of Prop 67, or if a future similar bag ban is passed. If both Propositions 65 and 67 pass, the one with the most votes would prevail. Thus, if Proposition 67 receives the most votes, the 10-cent fee would be retained by the stores. If Prop 65 receives the most votes, the 10-cent fee would go to the environmental fund. The fiscal effects of Prop 65. If voters approve the bag ban by approving Prop 67, but also pass Prop 65 by more votes than Prop 67 received, then potential revenues for certain environmental programs could reach tens of millions of dollars annually. If voters approve the bag ban by passing Prop 67 by more votes than Prop 65 receives, there would only be minor fiscal effects. Finally, if voters reject the ban in Prop 67 but pass Prop 65, there would be no immediate fiscal effect. However, any future statewide ban could trigger the provisions of Prop 65. Supporters of Prop 65 say that grocery stores should not be allowed to profit from the sale of reusable bags to consumers who are prevented from getting free bags. The supporters of Prop 65 also say that a bag ban's goal is environmentalism, so any money customers pay for reusable bags should go to environmental purposes, not to the stores. Opponents say that grocery stores should not profit from the sale of reusable bags, which cost up to 15 cents a piece to produce. Opponents of Prop 65 also argue that the only purpose is to distract from the real issue at hand, phasing out plastic bags. To actually protect our environment, vote yes on 67. Supporters of Prop 65, as of today, have made financial contributions totaling $2.9 million, all from the 5 plastic bag manufacturers based outside of California. This campaign is focused jointly on passing Prop 65 and opposing Prop 67. The opponents of this have made no financial contributions in opposition of Prop 65 at this time. And that completes Prop 65 and 67.
Thank you, City of Glendale, and Broadcast Production Associate Rob Townsend for making this taping possible. We hope we have given you the information you need to make your choices on these propositions on the November 8th ballot. As I mentioned in the opening, the League of Women Voters has a website that is designed to provide voters with more information about the propositions. Its address is cavotes.org. You may also find additional information at votersedge.org about propositions and their contributions, your personal ballot, how to get an absentee ballot, where your polling place is, and who is running for the state and Los Angeles County offices such as Superior Court Judge, Tax Assessor, or Sheriff. Thank you, and be sure to vote by November 8th.